Good morning. My name is Jennifer Conklin. I'm a staff attorney at Elder Law and Advocacy, and I'll be conducting today's presentation on tenant rights repair issues 101. First, I'll start with some background about Elder Law and Advocacy. ELA is a nonprofit organization. We have offices in Claremont and El Centro. Seniors need to be at least 60 years old to be eligible for our services. We provide free and low-cost civil legal services, Medicare-related counseling and advocacy, referrals to community senior service providers, and community education. Today's presentation is put on as part of our Elder Tenant Assistance Program. As part of our ETAP program, we provide legal services to at-risk seniors to assist clients in reaching a resolution prior to litigation. I specifically provide legal assistance to clients with significant habitability issues, such as lack of plumbing, bug infestations, and leaks. Today, we will cover California residential landlord-tenant laws as they apply to habitability and repair issues. Providing this legal information does not form an attorney-client relationship, and the information presented today does not constitute legal advice. We advise you to consult an attorney for advice regarding your specific situation. The applicable law for today's presentation can be found under the California Health and Safety Code, sections 17910 through 17998, and under the Housing Habitability Regulations, California Civil Code, sections 1940 through 1954. Under the California Health and Safety Code and Civil Code, a unit must be fit to live in and cannot have serious defects that impact the health and safety of the tenant. The unit must have adequate plumbing, heating and gas, electric lighting and equipment, waterproofing and weather protection, hot and cold water supply, sewage, adequate trash receptacles, floors, stairways, railings, and carpets, deadbolts on doors and locks on windows, and a working telephone jack. The standard is that each of the above mentioned be in good working order. Landlord responsibilities. The landlord has a responsibility to provide a habitable unit to the tenant at the time of the lease agreement. A landlord must also oversee all necessary repairs to the unit. The only exception to this is if the tenant is in violation of his or her obligations as a tenant. Tenant responsibilities. The tenant has a duty to inform the landlord of repair needs and give the landlord a reasonable amount of time to fix the repair, which is typically 30 days. The tenant is responsible for upkeep of the unit. The tenant must not have caused the problem now requiring repair. The tenant must keep the property clean and sanitary. The tenant must properly use all electrical, gas, and plumbing fixtures. The tenant must occupy the premises as it was designed to be used, with separate portions for living, sleeping, cooking, etc. In the event that a repair is needed, the tenant must allow maintenance and repair personnel to access the property. And as we will discuss later, the landlord has to give reasonable prior notice. The landlord has no obligation to repair when tenant's actions have substantially caused the condition. Landlord's notice to enter for the repair. A landlord may enter a unit to make necessary repairs or improvements. And the agreement to enter between the landlord and the tenant may be either oral or written. If the agreement is oral, the agreement must include the date and approximate time of entry. Entry will be within 1 week of the oral agreement. If there's an oral agreement for the landlord to enter, a landlord is not required to provide written notice of entry to the tenant. In the event a landlord's notice is written, the written notice must include date, approximate time, and purpose of entry. The notice can be either left or mailed. If the notice is left, notice may be left with someone of suitable age and discretion at the premises or left on, near, or under the usual entry door of the premises in a manner in which a reasonable person would discover the notice. 24-hour notice is typically considered reasonable. If the notice is mailed, mailing it at least 6 days prior to entry is typically reasonable. Notice is not required when the tenant is present and consents to entry at the time of landlord's entry. Again, reasons that may make a dwelling uninhabitable are ceiling leaks, damp walls, holes in floors, falling plaster, lack of or inadequate heating, missing or torn window screens, broken windows, defective plumbing, missing or defective smoke detectors, infestations of roaches, rodents, insects, or other vermin. If the common areas are unclean, inadequate trash collection, unsafe stairways or railings, defective electrical systems, or any other defect that threatens the health and safety of the tenant. The following are steps to take if a repair is needed. First, the tenant needs to determine that the tenant did not cause the problem. Next, the tenant should notify the landlord in writing of the needed repairs. Oftentimes, tenants notify the landlord verbally, and it's better that the tenant write down any complaints in either a letter or email to the landlord, or even on an online portal if the apartment complex has one. Because if the landlord disputes the complaint or tries to argue that they were not notified of the issue, the tenant can point to their written notice as proof. The tenant should also keep a copy of the communication. The tenant should take pictures of the unit conditions. And then lastly, the tenant must give a landlord a reasonable time, typically 30 days, to fix the defect. There are a number of remedies that a tenant can take if there was notice to the landlord and the landlord failed to repair the defect. However, there are risks associated with some of the remedies. So if the landlord fails to fix the defect within a reasonable time, a tenant can call the county or building inspector or health department to report non-compliance with the health and safety code. This may result in a unit being red tagged, or condemned, which would require the tenant to find alternate living conditions. A tenant can choose to repair the defect and then deduct the amount from rent themselves. This can result in the landlord serving the tenant with a notice to pay rent or quit for failure to pay the full rent. The tenant can choose to withhold rent entirely. This is generally used for serious defects, which again can result in the tenant receiving a 3-day notice to pay or quit for failure to pay the full rent. The tenant can move out or abandon the property. This could result in the landlord bringing a small claims lawsuit against the tenant for breach of contract. And then lastly, the tenant can choose to repair the issue themselves and then sue the landlord in small claims court for the cost. I'll go into more detail for each remedy in the following slides. The repair and deduct remedy. Under the repair and deduct remedy, a tenant must first determine that the tenant did not cause the issue. Then the tenant must notify the landlord in writing of needed repairs. The tenant should certify the letter and keep a copy. The tenant should also take pictures of unit conditions. The tenant should wait a reasonable time, which is typically 30 days. The tenant should determine if a serious defect exists. The cost of repairs must be less than or equal to 1 month's rent. And lastly, the tenant cannot use the repair and deduct remedy more than twice in a period of 12 months. Steps for withholding rent. Again, first, the tenant must determine that the tenant did not cause the problem. Then the tenant must notify the landlord in writing of needed repairs. The tenant should consider certifying the letter and keeping a copy. The tenant should take pictures of unit conditions. The tenant can wait a reasonable time or 30 days. And then the tenant should also determine if the defect is a serious breach. In order to withhold rent, the needed repairs must make it unsafe or unhealthy for the tenant to live in the unit. This includes issues such as a collapsed bathroom, continued presence of rats, mice, or roaches, no heating in any of the rooms, plumbing blockages, exposed wiring, or again, other conditions that place the tenant at risk of their health and safety. The tenant needs to determine the amount that will be withheld. This is typically the percentage or reasonable value of the portion of the property the tenant lost access to, or the tenant can withhold the entire amount. The tenant should place the withheld rent in a separate bank account. This will prove that because of the breach of implied warranty of habitability, the tenant withheld rent, and the tenant did not withhold rent because he or she simply didn't have the money to pay. This would be a stronger defense if the landlord then chooses to file an unlawful detainer action against the tenant. Lastly, the tenant should write a letter to the landlord explaining that they're exercising their right to withhold rent due to the breach of implied warranty of habitability. Finally, under the move out or abandonment remedy, again, the tenant should determine that they did not cause the problem. The tenant should notify the landlord in writing of needed repairs. The tenant should consider certifying the letter and keeping a copy. The tenant should take pictures of the unit. The tenant should wait a reasonable time for repair or 30 days. And then the tenant needs to determine if the defects are serious and related to the tenant's health and safety. And lastly, the tenant needs to notify the landlord in writing of their intent to move out by a certain date. On this slide, I've provided a number of other tenant resources. Housing is Key provides resources for renters, landlords, and homeowners. Disability Rights California is another nonprofit which provides advocacy services and information for individuals with disabilities. The Legal Aid Fair Housing Center provides advocacy services related to housing discrimination. The San Diego County Code Compliance is a great resource for filing complaints for non-compliance with the health and safety or building codes. And it also gives information on what code compliance specifically investigates. This concludes our presentation. Please feel free to reach out to us anytime with any further questions you have. Thank you.